Hi, this is the Business Guy. Let's talk about asset protection from lawsuits. To give yourself asset protection from lawsuits, there are a number of strategies that individuals can employ. So we'll talk about legal tools you can use, what to do, and how it works. Now, the bottom line is that you need to be proactive and set up the proper legal tools with professional guidance. Then you need to title your assets within these structures. 3 methods discussed here include the following. 1, limited liability companies. 2, using a trust to protect your assets from creditors. And 3, using retirement accounts. Business people can use one or all 3 of these methods. Each method offered here offers a certain amount of protection from possible lawsuits and creditors. And I need your help. Can you please click the like button below so YouTube promotes this video? Thanks so much. And if you haven't already, you can also click the subscribe button below so that when more videos come out like this, you'll be up to date right away. Now here's an important measure. Nearly all investors can take to protect their personal assets from lawsuits and creditors. Form a limited liability company and put your assets into it. Keep in mind there are limitations to the protection of assets offered by a single LLC. Clumping liability-prone assets into one LLC means that a lawsuit pertaining to one asset can leave the other ones vulnerable to seizure. Thus, it's important for investors to form more than one LLC to protect assets. Each LLC acts as a liability cubbyhole that keeps lawsuits away from the other assets. And that's one reason why so many real estate investors form a new LLC for every property they buy. Additionally, investors often use additional tools such as asset protection trusts and land trusts. So let's go ahead and take a look at how this works. Okay, so if you've seen another one of our videos, you know that we put each property into a separate land trust. This provides privacy of ownership. And then for the investment properties, that is the property that you don't live in, we make an LLC the beneficiary of each of the land trusts. And for your personal residence, we put it into a land trust for privacy of ownership. Now, the next strategy we employ is equity stripping. We take an LLC here and we record a mortgage, an equity line of credit mortgage, so no money is changing hands against all of those properties. Then if needed, in step 2, we have a third-party lender who can purchase the mortgage and put the proceeds of that mortgage into an international asset protection trust that we'll talk about here in a little bit. Forming an LLC allows investors to make a new legal entity that the law considers separate from the owners. As such, this separation creates a certain amount of liability protection. For example, if the LLC defaults on certain debts, its assets may be up for grabs. But the company protects the assets of the owners from that threat. The only assets of the owners that the lawsuit threatens are those that the owners placed inside the business. However, owners do need to pay debts they guaranteed personally. For example, if you sign as a guarantor for a loan that was made to the LLC. In addition, they may be responsible for things like unpaid payroll obligation. Illicit or fraudulent wrongdoing done on behalf of the LLC is another. LLC formation can offer decreased liability. This is in addition to asset protection from lawsuits. Liability protection means that when somebody sues the business, that is the LLC, it can shield the owners and managers from that lawsuit. And protecting assets come into play when somebody launches a legal attack on a member of that LLC on a personal matter. The LLC acts to protect the assets that the company holds. That is, it can shield the assets so that the creditor of a member cannot lose his or her membership interest in the LLC. Plus, it can protect the assets inside the LLC from seizure. It can also offer substantial tax benefits, by the way. That is, you can choose how the LLC is taxed. You can see that the IRS recognizes the LLC as a sole proprietorship, a partnership, a C corporation, or an S corporation. And within certain parameters, it's your choice. Additionally, there are a few other benefits to consider that you can take advantage of with your LLC formation that we'll discuss. Now, here are some tips when using the LLC to protect your assets from lawsuits. First of all, each time you buy a new property, make sure to create a land trust, as we discussed, for privacy of ownership. And then in turn, except for your personal residence, a separate LLC should own each land trust. Now, technically speaking, the LLC is the beneficiary of the land trust. So you put the property into a land trust, then you make the LLC the beneficiary of the land trust. And by doing so, you offer multiple layers of protection and privacy for each real estate investment. Keeping your assets held in the proper legal tools can help keep creditors at bay. In addition, keeping everything separate ensures that a lawsuit on one property does not leave the other properties vulnerable to seizure. So as stated, the concept of keeping a separate LLC for each real estate investment helps to protect the loss of all your investments from one lawsuit. So too, you can hold valuable business assets under separate LLCs. Again, this helps keep all of your assets away from creditors in the case of a lawsuit. So for example, you can have one LLC that does business with your customers. Then you can have one or more other LLCs that lease equipment, such as trucks, to your main LLC, so that when somebody sues the business that does business with your customers, there's nothing to lose. That is, your main corporation or LLC that operates your business signs lease agreements with the LLCs that own the equipment. And by taking these steps, if your main company winds up getting sued, there are few assets of interest for creditors to seize. Make sure that each business you set up is a separate LLC, keeping it apart from the others. And by separating these valuable resources, you spread out your assets and liability in the event that a lawsuit attacks your main company. An even stronger protective strategy is to have an additional LLC established offshore that holds your offshore bank account. You can do this as your company increases in profits and value. Offshore LLCs and accounts typically offer increased asset protection from creditors, and it makes a big difference when you hold your assets in a company beyond the reach of the local courts. Of course, jurisdictional rules and regulations apply, but for the most part, it is far more difficult for creditors to obtain assets tied up in an offshore LLC and offshore bank account. Stepping it up a notch higher, have the offshore LLC owned by an offshore asset protection trust. With an offshore trustee, which is our international law firm, you now have a trusted entity in place that is not bound by your local court orders. So if the judge demands the money to be returned, the trustee/law firm can refuse to comply. Now make sure that you stay on top of paying your yearly fees. This is very important. Keep your business entities all current and legal as you utilize this strategy. The fees are usually quite reasonable, and forgetting to keep your entities current can not only undo your asset protection, but can cause other litigation problems and late fees. So as we talked about, it's wise to utilize the strategy of multiple LLCs to protect your assets. You just need to stay on top of all the fees at hand to keep your companies current. You need to retain a registered agent at all times for your business entities. Now, a registered agent is not only required for LLC formation, both in the U.S. and offshore, but it's also an important part of the strategy to protect your assets from lawsuits, because they can guide individual business owners through the process of keeping documentation and fees current. And they can also help to ensure that these entities remain in good standing. In fact, our organization performs both company formation in the U.S. and abroad, and is in the registered agent profession. Make sure you pay close attention to real estate liens that may exist on any part of your real estate portfolio. You need to increase the number of companies as you increase your holdings. It may also be beneficial to have your company establish a 401k retirement plan. Retirement plans offer an increased amount of asset protection from creditors and typically cannot be seized in litigation. One exception is in divorce. Asset protection trusts can offer the most powerful security to investors and business owners. So it is another option to take advantage of. Investors have the choice of either setting up an onshore or offshore trust, or both, depending on their needs. For the most part, it is recommended that an individual set up an offshore trust for asset protection if he or she has a large net worth. Let's start with domestic trust. To understand this a little better, know that in this context, there typically are two types of trust. One type is what we call a U.S. domestic grantor trust. In the U.S., it is tax neutral and does not require significant compliance standards. The formation of this type of trust usually obtains a pass-through of the tax burden to the trust grantor, that is the one who formed the trust. Furthermore, formation of a domestic trust is under the jurisdiction of the local courts. The second type of trust is a foreign trust, and these are most effective in terms of asset protection. So the second type of trust is a true foreign trust. The foreign or offshore trust is a much more powerful tool to protect assets from lawsuits. The formation of this type of trust means that local courts do not have the rights to easily seize assets in the trust, and this is because the funds and the trustee are located offshore. And as far as U.S. domestic trusts are concerned, they also present many issues for investors seeking to use the trust for asset protection. Some of the problems offered by the U.S. domestic trust include conflicting law issues. They can vary from region to region and confuse both the attorneys and the judges. Full faith and credit laws can also cause certain state laws to apply to other states. Plus, judges who want results may not always decide based on the law. They often rule based on the results they seek to obtain. Fraudulent conveyance statutes can interfere with domestic trust transfers in a way that offshore trusts do not allow. And keep in mind the fraudulent conveyance we're talking about here is by and large a civil matter and not a criminal one. So if a judge issues a fraudulent conveyance ruling, that means that judge can also seize the assets in the domestic trust. However, when you put your assets into an offshore trust, that judge does not have jurisdiction over our foreign law firm/trustee. In addition, bankruptcy law may also give creditors a free pass into your trust's wealth if it's located in a domestic trust. So the big question is, does it work? And the answer is, domestic trusts, as we've seen, do not work well, and offshore trusts work extremely well. To underscore this, every offshore trust that our firm has established for clients has been effective at keeping its assets from creditors. And we also believe that we have established more offshore trusts than any other firm in the world. Also, with any trust, one step you cannot ignore is remembering to revise your trust for your children. First of all, anytime you have a new child or wish to add another beneficiary to the trust, you need to revise the trust as soon as possible. Let's say a child is lazy. A child may exhibit behavior such as drug use that concerns you enough to withhold your wealth from that child. You can include such restrictions in your trust. If you feel that one of your children do not deserve a piece of your trust, then this is a factor you should consider. You can also put certain stipulations in the trust so they must achieve certain milestones before they receive assets from the trust. For example, they need to get a college degree, a master's degree, or a doctorate degree. There are 3 types of retirement accounts that may offer some additional asset protection from lawsuits. First is the qualified retirement plan, which is one of the most protected types of retirement accounts. This includes the common 401k and 403b employment plans. These retirement accounts cannot be touched in civil court judgments and may still be maintained even if one declares bankruptcy. Including Roth IRAs and traditional IRAs is a second type of retirement plan that can protect assets from lawsuits. Bankruptcy law typically allows you to keep up to $1 million of assets in those plans depending on the state. In addition, your state will determine any civil court judgment angles as legal statutes and interpretations can vary depending on where you live. Furthermore, the overall protection typically offered by these plans varies from state to state. In California, for example, an IRA may be seized if it is determined that you can be supported in retirement through other means. Last of all, SEP IRAs typically receive unlimited federal protection from bankruptcy, but the level of protection offered can vary from state to state. Some litigation uncertainty exists with these types of accounts with respect to civil judgments. If you have any questions about protecting your assets from lawsuits, please give us a call at the number below or fill out a free consultation form on our website. Please click like, subscribe, and share this video with others. Until next time, this is The Business Guy.